We are going to conclude with a very timely segment. Before I introduce our speakers, though, the materials from today are available and are going to be emailed to everybody here. So the PowerPoints and such. Yes, Scott, thank you for reminding me. Will be emailed out to everybody, so you will get a copy of that. And my ad director would like me to remind you to please consider taking our nomination form for Leaders in the Law, and if you know an in-house attorney who you think should be honored, please, it's a very simple form, please send it in to us. Thank you. So our last segment is very timely. It is managing a harassment and discrimination crisis in the Me Too era. Our moderator is Gareth Notis. He is a labor and employment partner with Morrison Mahoney, one of the region's leading litigation firms. Gareth provides advice on hiring, promotion, discipline, and termination decisions for employers in the education, transportation, and government sectors. He is MCAD certified to train as well as investigate discrimination and harassment claims, and guides companies on drafting employment policies and procedures, handbooks, applications, job evaluation forms, and other documents that affect the employment relationship.
Thank you, Susan. So my background really started in litigation, and so I think that gives me sort of a unique perspective on the Me Too movement and labor and employment matters in general, because I've seen where crises have evolved into litigation. So it gives me a perspective on where things went wrong and how it might impact the legal exposure of an organization or a company. I think we've got a great panel today. I want to do some introductions. To my right is Sandy Lish. Sandy is the CEO and co-founder of the Castle Group. Sandy, did you want to tell a little bit about what you do?
Sure. So we're a 22-year-old women-owned firm based here in Boston in the Charlestown Navy Yard. We work on crises as well as other things. About half of our business is public relations, and the other half is corporate events management. I run the PR business, and a good deal of that practice is focused on crisis. We work on crises around the country. I think over the past, really, 5 years or so, it's really exploded in terms of the types of crises, the frequency with which they occur. And I will give a little teaser, which is that I think many of the crises become crises because of poor communication, not necessarily because of the issue at hand. Gregg?
Thanks, Annie. My name is Gregg Rubenstein. I'm Associate General Counsel, excuse me, at a company called Beacon Health Options, headquartered here in Boston on State Street. We serve in the behavioral health space and help mostly Medicaid members get the behavioral health they need. But my reason for being here today and my role is I head up the employment law function, I guess, from a legal perspective at Beacon Health, and get involved in pretty much all kinds of things that deal with harassment related or any kind of discrimination claim, and hopefully can provide a little bit of insight as to how we deal with it from an in-house perspective.
Great, thanks, Greg. So today's agenda, obviously the topic is Me Too and how that's impacted crisis management. I think the general consensus as we were preparing for the presentation is that the Me Too movement, which really just evolved within the last year, has dramatically impacted how organizations, companies, employers are handling things from a legal perspective, and I think even more importantly from a public relations perspective. So the landscape has changed dramatically. So today's agenda, we're first going to give just a little bit of a background on the Me Too movement, a slight, very small synopsis of sexual harassment and discrimination laws, the role of training and how that can assist with mitigating a Me Too crisis or other discrimination and harassment crises that evolve, the role of an investigation. I think Gregg has a lot of insight into this area. What does a private employer do, a public employer, when they're faced with a social media post about harassment? What type of investigation are they going to undertake? Are they going to take an internal investigation with their HR department and general counsel, or are they going to go out and hire a private investigator? Is it going to be a lawyer? Is it going to be somebody who's not a lawyer? I do private investigations as a sexual harassment investigator. So that's an example of when a private employer would go out and retain an external, neutral investigator, and whether or not that investigation should be privileged or non-privileged. In other words, you're retaining an attorney to conduct the investigation in an attempt to keep it confidential, to keep communications amongst the company confidential, and ultimately, hopefully protect and insulate the company from claims down the line. And then Sandy's going to really address the public relations strategy and elements of a triage strategy, things that the company's organization should have in place from a public relations standpoint, the strategy they should have, the team that they might want to have in place, and who they want to retain from an outside standpoint. Then we're going to touch briefly on some recent events, the Matt Lauer situation. We're going to take a look at that and see how that was handled, what went wrong, what went right. We're going to talk about the recent Google crisis that actually just evolved within the past week, involving Andy Rubin, who was the father of Android. And then we're going to, if we have time, get to some hypotheticals. We'd like this to be an interactive panel, so if you have questions or comments or anecdotes that you want to talk about or bring to the attention of the panel, feel free to break in at any point. So the Me Too movement really started within the last year in October of 2017. I think the Anita Hill crisis that really revolved around the appointment of Clarence Thomas back in 1991 is really seen as the watershed moment for public awareness of sexual harassment. But last year, when the Harvey Weinstein issues came to light, that's when the movement really took off, and I think it's changed the landscape dramatically. There's certainly been some tremendous positive impacts about the movement. Certainly, it's raised public awareness. It's hopefully rooting out and eradicating assault, sexual harassment, and other forms of discrimination in the workplace. It's forcing companies like Gregg's, I would imagine, to take an internal look at their policies, their handbooks, and re-examine what type of training that they should reinforce or even institute that's going to help protect the company. And ultimately, hopefully, the goal is to make a safer and more productive workforce. Some of the negatives, and I think we'll see this in the example, particularly with Google, it's causing damage to companies' brands and their reputation. It's making it difficult to retain and hire employees. It's increasing claims and litigation, something that we see on an everyday basis. And it's creating resentment amongst employees. And so it's really poisoning the workplace environment in a lot of different ways. Just this morning, Google, a story came out on AP about the Google situation. And their employees, they have 94,000 employees worldwide. They staged what's called a walkout for real change. And this was in response to a New York Times story that came out last week about Andy Rubin, who was the father of Android. And he had been given a very large golden parachute severance package of $90 million in 2014. And the real reason at the time for his separation from the company was a consensual relationship that he had with an employee that developed into a sexual assault. And Google investigated it, found out that there was legitimacy to the allegations, and he was let go. Last week, on October 25th, the New York Times released a story that really brought this to light. And internally at Google, they've really had to do some triage because of the backlash that it's caused with their employees. Sandy, did you want to talk just sort of briefly about how the reaction of the employees, I think, is particularly interesting because it's not necessarily coming externally, it's coming from internally. So can you talk about maybe some of the impacts that this story has had on the workforce at Google?
Yes, so as I mentioned before, a lot of the times when a crisis occurs, it's because of poor communication, lack of listening internally to concerns in the workforce, and lack of action and response if there is listening, or a slowness in acting and responding. And so we were talking outside the room about what is it that the employees want. And it's actually not just the employees, it's also vendors, it's temporary workers, and it's sort of ancillary audiences. And people don't just stage a walkout the minute they get upset about something. There has to be a lot either happening or not happening to lead up to this point. It's very well organized, obviously very well publicized, and we're talking about what it is that, that the employees want, and I need my glasses to read this, but this is what they want. They want Google to end its use of private arbitration in cases of alleged sexual assault and harassment. They want the publication of a transparency report on instances of sexual harassment, further disclosures of salaries and compensation, an employee representative on the company board, and a chief diversity officer who could speak directly to the board. Now, from your standpoint, I mean, it doesn't sound like any of these things are requests that are so outrageous that a company couldn't respond in some way, or at least take them under consideration before it got to this point.
None of them really are. I think and yet, the lawyer in me will always say that the devil's in the details about what exactly people want and what they'll accept. Take, for example, the one request about more transparency about salaries. So recently, if folks haven't heard, here in Massachusetts, we enacted new law about that you can't, as an employer, inquire about someone's previous salary, because that was always, not always, that's too much, oftentimes used as a proxy to figure out what they would pay. And it had certainly the perceived effect, if not the real effect, of perpetuating pay disparities on the basis of gender in particular. So, great, more transparency, but I don't know if more transparency is always the best thing, and it depends upon what kind of transparency we talk about. So certainly nothing in there that's a game stopper. My gut says that if someone really took it seriously, and I think that they should, and they met with some panel or group of employees who wanted to represent them, what the employees wanted, they'd find it's a little bit more difficult to figure out at the end of the day what actually gets disclosed and what doesn't. It doesn't mean that we don't engage in a real good faith process to talk about it. And I think some of those things will almost certainly happen because they're easy gives, if you will. But I think as we get into more of the crisis and dealing with the crisis, you're going to find that, well, I will say from my perspective anyway, so much of it and how one should respond to these kinds of situations, it is incredibly important to have some guiding principles that are your bedrock of how you respond to these, and it's those principles that dictate the specific actions that you take. If you try to focus on what's the specific thing I need to do, my experience anyway is you tend to get into more trouble than you actually solve it, as opposed to focusing on the principle and then figuring out how do I solve for that particular principle in the circumstance. But maybe we'll get there.
So from the investigator's standpoint, the transparency is sort of a double-edged sword, because oftentimes, as many of you have probably experienced, there's more sides to the story than just what the accuser has to say. And one of the principles of an investigation, and I think Sandy will talk about this as well, is respecting the confidentiality of the process, and not only of the victim, but also of the accused. And so you really walk a fine line with some of these requests. For example, getting rid of the private arbitration process. That's a difficult pill for a lot of employers to swallow, I think. What I found kind of unique about Google's response, and it really shows how the Me Too movement has changed the landscape, they came out and disclosed, this was their response, and Gregg and I were talking about this before, they didn't take accountability necessarily for the mistake that they made in 2014 when they gave this executive the large parachute. But they did acknowledge that there was a problem and that they were working towards making progress. But this is the interesting part to me, that they came out and they said in the past 2 years, they've fired 48 employees, including 13 senior managers, for sexual harassment without giving them a severance package. So here's a large I think, a company with an excellent reputation as being cutting edge, technologically savvy, and innovative, and they're actually, in this day and age, announcing that they've terminated employees and suggesting that it was without a severance. That probably would not have happened 10 to 15 years ago. So how's the Me Too movement impacted claims and litigation? So prior to 2015, really the trend, at least in Massachusetts, and we'll look at the next slide that talks about nationally, the trend in claims, charges being brought at the MCAD, which is the Commission Against Discrimination, were declining every year. And I think that was a product of probably good training, more robust policies with employers. But the Me Too movement dramatically changed that. So as you can see, at the EOC, just in October of 2018, they announced a 12% rise in charges within the past year. Back in February of this year, you might have seen the article in the Globe and the Herald, the MCAD, which isn't very good about tracking data, but they had a huge uptake in sexual harassment complaints just in December and January of this year. So I think we're seeing a lot of increase in claims from the litigation standpoint. I think that we're at a unique time, not just because of the Me Too movement, but because of the political discourse that we're having right now, and and personally, I've seen a number of claims that really arose out of the 2016 election, and what was perceived as a disagreement about politics evolved into a dispute about race, about gender, and about a whole host of protected classes. And so I think not only is the Me Too movement, but the current political landscape is really, I think, contributing to the increase in claims.
Well, and let me just throw one quick thought in here. For me, anyway, one of the more interesting aspects of that fact that we're getting more complaints being filed is the recognition that the standards, at least the legal standards anyway, haven't changed one whit. The laws against harassment and discrimination, Title VII, 151B here, I always get confused. Here in Massachusetts, the laws haven't changed from 5 years ago or 10 years ago. So if we're looking for, if we think that the Me Too movement has somehow changed the standard, it hasn't. We are expecting people to, we're judging people against a standard that is unchanged from previous years, and quite frankly, in an awfully long time. We've added a couple of categories to the protected status over time, but the standard of what is acceptable and what is not acceptable has not changed. What has changed, I think, is the willingness to report. And so I think the next thing that we ought to be keeping an eye out for, quite frankly, is whether or not with more reporting and more examples of alleged harassment or discrimination, or both, will we then see a movement to try to change the standard by which we evaluate more facts and more fact patterns? That's what I'm actually also keeping an eye on, and I think will be interesting to see. It's going to take more time, but I do think, keep in the back of your head, at a certain level, nothing's changed, and yet it has.
And that ties into the investigations as well. So nothing's changed from a legal standpoint about the requirement of an employer to initiate an investigation. The standard has not changed, but I think the sensitivity to it, and maybe perhaps, and Gregg can probably speak to this, what the threshold is for initiating an investigation and whether you're going to take it external, perhaps in this day and age, has changed. Gregg, have you seen any shift in maybe how Beacon and the industry as a whole has really changed its approach to investigations when you get a complaint of harassment?
So, I'm not going to say luckily, because I don't think it actually has a lot to do with luck. We at Beacon have not seen a change. I know that we take these matters seriously today, and I'm glad to say that we've taken them seriously for a long time. When we get in a report, we're going to investigate it, unless it is so facially nonsensical, for lack of a better term, or not, so all of these things, I think it's helpful to understand the legal context in which they arise, right? Because hopefully we'll talk a little about this, there's the legal side and there's the non-legal side. Not surprisingly, I tend to focus a little bit more on the legal side. I'd like to think I get paid for that. But I fully recognize that there is a non-legal component to all of these. They work together. So we haven't seen an uptick in reported harassment, thankfully. We have not changed in any way our policy as far as investigating reports of harassment. But it might happen. You never know what's going to happen tomorrow. And we're going to take it, from my perspective, and this is really me and certainly not anything on behalf of Beacon, but we take all the claims seriously. We evaluate them. Some have more substance than others. That's what happens. The ones with more substance, we respond to differently than the ones that we have that I think have less substance. But it goes back to those principles that guide you, which is when I get one of these complaints in and I start talking to the folks who are going to do the investigation, because generally I like to not personally do them. I like to have HR staff, for the most part, do them. But I tell them the same thing every time. I want to be guided by doing the right thing. We can differ on what that right thing is, but that's the standard. And if we stay true to that, we'll probably be okay most times that we come up.
So as Gregg mentioned earlier, really the standards and the legal standards for sexual harassment have not changed for many, many years. Just in general, we have a couple different types of harassment. We have what's called hostile work environment harassment, which I think probably is everyone's most familiar with. And that's an unwanted contact of a sexual nature, typically involving gender, and it's offensive both subjectively and objectively. And that's the legal standard. And then we have quid pro quo harassment, which is a suggestion of sexual favors in exchange for either job preservation or job advancement. The standards haven't changed. I think most employer handbooks and policies internally concerning harassment and discrimination are going to be more rigid. They're going to be more stringent than what the law imposes. And so oftentimes, you're analyzing a situation not only from what the legal perspective is going to be down the line in the exposure, but are you complying with your policies? And typically those policies are going to be a lot more stringent. Many times, zero tolerance. So Gregg, in your experience, are most employers going to more of a zero tolerance type of approach when they get a harassment complaint? Or are they instituting conventional progressive discipline, or does it just depend on the circumstances?
I think it does depend on the circumstances. I will tell you that as I practice in this area, I'm not a fan of zero tolerance policies. As a lawyer, I have an inherent problem with the words like all and always and never, because I can always find, and almost always find it, see, I can, not always, but almost always find an exception to them. Every now and then I can. And what is so involved, and I can't tell you how many of these types of claims I've dealt with because I lost track a long time ago, but there is always the human element involved in all of these claims. It's what attracted me to the field in the first place. I actually studied labor and employment law in college. I knew that I wanted, like I was at that point so interested in it, and it's what makes these cases so important as well, that it really does involve human interactions. And those interactions are on a sliding scale. It's easy to say, certain actions are so egregious that they are per se wrong and not tolerable and a employment terminable offense. But honestly, they don't happen that often, at least not for me in the cases that I'm involved in. It's much more somewhere in the middle of the scale. I get, and and people's sensibilities as to what is acceptable and what isn't, and actually trying to get them to talk to each other a little bit more than anything else. You know, when someone passes by and calls someone hun all the time, because that's what they've always done, and the person receiving it doesn't like it. I don't know if it's really sexual harassment, because they seem to call a lot of people that, but what I've found is, you know, again, keeping your eye on the ball, and hopefully we don't have to call Sandy for that crisis, but keeping your eye on the ball. What is it? Clearly there's a problem. How do we solve the problem? And try to get the two employees to actually talk to each other, focus on why somebody doesn't like it, and they oftentimes don't say it, right? My experience is they just fume about it until they get so angry and it's gone on so long that it turns into a harassment complaint. And then it boils up to me. And I start digging in, and it's like, well, how long has it been going on? I say, oh my God, it's like 6 months, 2 years. I said, did you ever say anything about it? Well, no, I mean, they should just know that I hate that. And I was like, okay. But focusing on really working towards solving the problem and understanding that these are inherently human relations problems more often than not. I don't know if that answered it, but it sounded good.
Sounds like you take a common sense approach to most
try
situations.
to.
Great. So just quickly, harassment is not limited to just sexual harassment or gender. It can take the form of all protected classes, race, religion, age, disability. I've handled all types of those claims. Sexual orientation. Massachusetts has recently enacted a marital status, military, veteran status, and arrest record's been around for a while, but some new protected classes that aren't recognized on a federal level just yet. There's also a claim called associational discrimination. That's when a witness or somebody who's not in a protected class is subjected to harassment. And I think that's something that we'll see unfold as we look at some of the real-life examples. But it's when somebody who's not in a protected class, the classic example is you have a white male who's under the age of 40, not in a particularly religious class, witnesses incessant harassment of his coworkers and feels harassed, and then he reports it and then is retaliated against. That's somebody that's associational discrimination, and that can lead to liability in and of itself. Yes? It is not. It is. I handled a claim last year where the employee was ridiculed because of her political beliefs. And that in and of itself did not lead to, it wasn't a protected class. But because some of the rhetoric involved national origin, it evolved into a viable claim. Briefly, the role of training. I think training's been around for a long time. It's not a legal requirement, but it's absolutely a prudent practice for all employers. The goal is to educate the workforce and hopefully show down the line, if you are involved in litigation, that you have reasonable practices. Typically, most people will say robust training, comprehensive training on a 2 to 3 year cycle, but that's not taking into account more frequent refresher courses, videos, and the like. Gregg, in the private sector, how often are you conducting training, and does it differ from a supervisory managerial level to your more non-managerial employees?
So for us at Beacon, we do video-based training on an annual basis. Everybody's got to watch it. It's my favorite time of the year. And then there's one module that every employee takes, and we have a separate module for supervisors that they have to go through. So we take it seriously, I think. All these trainings, if you've ever been through them, are a little bit hokey, quite frankly, but I think that's actually a good thing. It makes people think about it, it makes them consider it, and we do it every year. And it's the kind of thing, I believe, that if you just hear it again and again and again, you increase the odds of when the situation presents itself, you do the right thing. and you remember what the training taught you. And if the more times you hear the example in a training, the more likely you are to do what is the appropriate action in response. Big believer.
So on to just the investigation, we'll briefly touch on that. Obviously, if the responsibility of an employer when they get a complaint is to do a reasonable investigation, and they have to do it timely. I think in most instances, I've seen liability evolve not when the investigation isn't reasonable enough. I think it's pretty rare to argue that the employer didn't undertake reasonable steps interviewing the key players, but it's when it's not timely. And that can lead to independent liability in and of itself. Confidentiality, I think, is critical to the process. And like I said earlier, respecting the privacy of both the complaining party but also the accused.
Can I actually ask you a question?
Sure.
One of the things that we deal with a lot from a communication standpoint when there's a crisis is sort of what is an internal investigation, what is an independent investigation, and sometimes why a crisis turns into a crisis is because the stakeholders feel like the investigation really wasn't impartial. So maybe just the nuance between internal, external, and then external and independent.
Sure. So one of the examples we're going to look at is the Matt Lauer situation. And it was, generally perceived as bungled by NBC News. They did what they thought was a neutral investigation. They had their general counsel take charge of it. So that was the internal investigation. And I think that led to a lot of criticism publicly and amongst their employees. Ann Curry, a former anchor on the Today Show, came out and blasted them, saying that this can't be an impartial investigation just on its face. And so I think it really depends upon the severity of the situation and just how, also the level of the executive in question. If it's a supervisory versus a non-supervisory situation, I think that a neutral external investigation is always going to be prudent, especially if you're anticipating public media attention for the investigation and the allegation.
So I would just add one other thing on that. I think a lot of times the independence of the investigation tends to be viewed in hindsight to what actually happens. I think about this Google incident that we were talking about. I think that a lot of people are judging the investigations by the result that actually happens. And so when you do these investigations, you might do a great job, but I think you have to consider where you're going to end up to and what decision you ultimately make, and understand that will have a strong likelihood of coloring how people view the investigation that you did during it. It's hard to divorce them.
I think that the investigation not only has to be, impartial, perceived as neutral, but in the interim, after you've received a complaint, again, this goes back to the timeliness of it all, interim measures should be in place. And I think, what we'd like to see, and one of the things that's evolved out of the Me Too movement is more anticipation on the part of employers to have a plan in place to immediately investigate interim measures that should be taken based upon the severity of the complaint, the willingness of the complainant, what the complainant's desires are, and how many complaints they are and whether they're ongoing. So those are all things that in the interim after a complaint is received, I think are critical to imposing. In the NBC News situation with Lauer, they didn't respond quick enough, and people were out making comments about the situation, and the failure to sort of triage it quickly and prudently led to a lot of criticism. Some of the internal measures that you might want to consider, we have up there on the bullet point, prohibit communications between the harasser and complainant. That's pretty obvious. You're going to consider whether to put someone on administrative leave and whether it's going to be paid or unpaid, and whether to transfer the harasser. Gregg, in your experience, how often and how frequently are you putting someone on paid versus unpaid leave when you have a legitimate claim that your initial investigation is revealing to have some teeth to it?
So, as a general rule, if I've got a facially legitimate claim, and I've got a direct reporting relationship. My first rule of thumb is I want to talk to the person who's made the complaint. And I want to ask them what it is that they would like. What do they think is appropriate? I always like to ask that, or I like to have that question asked, if I'm being more precise. I like to have that question posed to the person. I don't always agree to what they want, but I always want to know what they want. Sometimes they don't want to go out. Sometimes they want to continue working. They don't want to be perceived as going out. And if I put them out on a paid leave or unpaid leave, they're going to view that as some sort of retaliation. And that's not necessarily what I'm looking to do. It may be that I have to, right? It may be if it's so severe and there's a direct reporting relationship, I gotta get some space in between them. But I want to know what that person is interested in. And here's a little, I don't know if it's a secret because I'm telling it now. I learn a lot about what I think is going to happen when I get an answer to that question as to what the person wants. If the immediate response is, I want 5 years severance and everything else, and it was what I would call a relatively minor allegation of inappropriate behavior, I get informed by that. That tells me that there's something else going on here when I hear outrageous numbers. If I hear, look, I really just want it to stop, and I want to figure out how to deal with this, and I couldn't do it, that informs it too. And it guides me in what I want to do. But as a general rule, if someone's going to be absent from work as a result of an investigation, that time will be paid. I'm not going to put there should not be a cost associated with reporting harassment or discrimination. I mean, it's really no more complex than that.
Have you had situations where you've received a complaint and then shortly thereafter there's an MCAD or an EEOC charge that sort of throws a wrench into the whole process? And does that change your approach to not only the leave situation, but remedies that you might want to take or the investigation you're going to take?
Maybe. Lawyers love that. That's my favorite answer. Maybe. So my general approach is when I get notice that a charge has been filed, and Beacon, by the way, is nationwide, so I get them. It might come from the EOC, it might come from the MCAD here in Massachusetts, but to an administrative agency, or by the way, some places they just go right to court, so I get served with a lawsuit. I get the charge or the lawsuit in, and I immediately call the head of HR for the region in which the complaining current or former employee is located, and I say, hey, not for nothing, but I just got this charge in here, what's going on? And when I get upset, frustrated, is I say to folks, look, we've got 5,000 employees at Beacon, more or less, and I believe that at 5,000 employees, there is a certain level of claims that will be filed on an annual basis. I like to think that we're doing our best to keep that low, but at a certain threshold, there just will always be some level of activity in this field. And that's what I would call part of doing business. So when I get upset when these things come in is not so much that they come in and of themselves, but I hate when the first time I have heard about anything is when the charge is filed. I want to know about it. In my ideal situation, somebody has complained about it internally. There's been some response internally. We've thought about it. We've made a decision. We've tried to do something or determined that we don't need to do something. That happens too. And if the person is upset with that and they want to file a charge, so be it. I don't want to say I'm happy about that, but I've known about it. I've seen it coming. I'm prepared for it. And hopefully I'm comfortable with the decision that we made that led them to filing the charge. But it doesn't always happen that way. And again, it sounds hokey. It sounds hokey to me as I say it in my head before I say it aloud, but I really do try to be guided by doing the right thing. So we had a claim once where I heard nothing about it, The first I heard about it was a charge that came in. I did exactly what I just said. I called up the HR person, and I said, hey, what's this going on? It sounds pretty legit. I can see why this might be a problem. And the HR person said, oh, yeah, I'm not surprised that person filed a charge at all because, we've been trying to work through something and we haven't done anything yet. Okay. So I don't I have to deal with the charge, but I continue to believe, and so far have been successful in, I still got to deal with the underlying problem and the concern. And if I can focus on doing that, dealing with the charge will work itself out in the normal course. Oftentimes, there are people who file charges for bad reasons. I've done enough of this that I know it to be true, at least in my own experience. But they are few and far between. They are not the majority of folks. Most people file these charges because they are genuinely concerned and believe that they have been wronged. And while that's not always true, most of the time it's an effort to try to get more attention focused on something. And if something needs to be focused on it, then we need to do it. And we just need to, that's our job, is to get them to the right place, at least as far as we can. We might not agree on what that is, but I want to be able to say to myself, I did everything I think is reasonable to try to address this person's concerns.
And I think the charge complicates the employer's responsibility to investigate. I mean, the duty still exists, particularly if you have the employee who's an ongoing employee, has not left, is not alleging that they were terminated because of discrimination or harassment. And I think the employer still has that responsibility. So from a private employer's standpoint, does that change your evaluation of whether you're going to take the investigation outside, external, versus keeping it internal? When you have that charge that's filed, the employee's still working for Beacon or whatever employer. Does it change the equation for you?
That fact doesn't. I think what really drives that decision, at least for me, is the nature of the allegations themselves and whether or not how allegedly severe and pervasive the behavior actually is. If it's a less severe and pervasive case, I'm pretty much going to keep the investigation internal still. I happen to be a fan of doing more of our own investigations. I'm not as big a fan of using the outside investigation. And again, these are, very much based on personal experience. They usually aren't that complex, actually. I mean, there's what somebody said and what the other person said, and truth is usually somewhere in between, but gathering all the positions and what people are going to say usually isn't that hard. One of the reasons why I happen to like this field of law is that at a certain level, everybody gets the story. You don't know who you believe, but you understand what's at issue. He says that she harassed him. She asked him out on a date. He said no, she wouldn't let go. True? Not true? Not sure. But I get what's going on. I understand what the issue is. So I tend to use more internal investigations because I think I can get a good handle on the facts. If there's got to be some level of complexity or a real concern about that it's going to blow up bigger, and I want to be able to point to somebody else as having done the investigation. I mean, it's a mitigation measure.
I think you touched on frivolous claims that don't really have a whole lot of legitimacy, that somehow get brushed under the rug. I think the big danger for any employer is the retaliation claim that evolves out of that. And the lack of a response, of a timely response, the brushing off as unimportant claims of employees can lead to independent liability, even if that claim is ultimately frivolous. If the employer allows it to fester, and it leads to some adverse employment action being taken against that employee because they complained about it and there were some consequences that were negative, that can lead to independent liability. So I think when I'm involved in a situation, I get a complaint, a client calls me, the first thing I have a focus on is retaliation and making sure that the the individual who's alleged to engaged in the conduct is not lashing out at the employee, is not lashing out, importantly, at witnesses who might support the story, because that is just, it's a huge exposure for the employer. So we're going to shift gears now and talk about the public relations component to this. So Sandy's going to address how the Me Too movement has impacted public relations. But before we do that, a quick question.
Right. I also, without derailing the conversation, I also think that there's a lot of eyeballs on organizations that don't have gender parity at the C level or on boards. And so someone can say that behind closed doors, but if it's a public company or if it's even a private company that is visible, they're going to get called out for not having that parity, or at least a decent type of balance across gender and race. I know that's not what we're here to talk about, but. So from a communication standpoint, I gave out these kind of guiding qualities, and I want to say that these guide the work that we do on crisis communications across different types of crises. But with regard to Me Too, a couple of things. One is it's a highly emotional topic, and it's a topic that's in the public eye. And so just by using hashtag Me Too, whereas in the past, an allegation might not get a lot of eyeballs, someone who's quick to go to social media and use that hashtag immediately amplifies the situation. So I want to talk for a minute about what is expected. And when I talk about transparency, I don't mean sharing salaries. I mean transparency, not necessarily even in sharing the name of the alleged perpetrator, but transparency in process is sometimes enough. Transparency in policy and procedure, transparency in what to expect regarding an investigation. And that's really important. A lot of times the crises explode because people don't know what's happening behind the scenes. And even in some instances, institutions that we work with are actually doing the right things, but nobody knows about it. And so they're being accused of not having a good process or not having any process, when in fact that might not be true. So it is really important to share what is being done when an allegation is being made. And I also, in terms of transparency, I don't necessarily mean sharing the facts. Obviously, there are privacy issues with regard to employees and their rights. Dealing with an institution right now, a higher education institution, that is really trying to balance, should we share the name of an alleged abuser? And by the way, everyone on campus sort of already knows who it is anyway, or not. And it's a matter of balancing risk. You alluded to this before. It's the brand and reputational risk of being true to this organization's culture and feeling sensitive to the people that feel they have been wronged, and the litigation risk of sharing, who the person is. And sometimes there's no absolutes there either. It's based on the organization, it's based on their culture, it's based on their appetite for risk, it's based on their insurance carrier, it's based on a lot of things, but there is no black or white. Sometimes you do need to say the name of the person in that community letter, because if you don't look like you are being authentic. If everyone knows who it is, and your reputational risk longer term might be greater than the risk of what that potential accuser could do from a litigation standpoint. Speed is really important. Obviously, there is no time to sit on your hands and wait to address something that's being accused or alleged, and there's other communications professionals in the room that I know you heard from. It's a 24/7 news cycle, and if the media are already calling you, the story's out. I mean, by the time it gets to them, it's already been somewhere on social media, and so you don't have time to kind of wring your hands and figure out who your team is. Consistency is really important. When you're in the heat of the moment and it's your organization that's dealing with the crisis, even if you have a great and solid plan and you've vetted what you're going to say and you've vetted how you're going to handle it, people start to freak out because sometimes you've done what you agreed you would do, and the next thing to do is sort of nothing. Like what's going to happen is going to happen next. And it feels very hard to not respond or say something else or release more information. And the consistency of what you're releasing, saying the same thing is very important. The more you put out there, the longer your story is going to stay alive. And the more you drip out there, the more your story is a new story every day. Relaying your information with confidence, being compassionate. Obviously, again, this is a very, very emotional topic, and you have to show compassion to both sides of the equation, because if there's an investigation happening, nothing's yet been proven, there are two potential victims. And then authenticity, and this speaks to the risk piece too. What is right for your organization? And I think those of us in communications have seen a real shift from issuing statements that were legally and factually accurate and issuing statements that are a little bit more emotional and heartfelt, not the non-statement statement like, and I have a cartoon at the end that will speak to that, but really actually saying something.
Just quickly on the consistency topic, from a legal standpoint, the precedent that you're going to set with whatever action you're taking is oftentimes very critical. If you've taken a harsh approach in one situation and a not so harsh approach with your current situation, the inconsistency with that approach is going to ultimately harm you in the litigation. But I also think going forward, how the company is addressing things, the consistency, if it's handled inconsistently, it's going to set a bad precedent going forward in how you're going to adhere to a certain situation.
So why advanced planning? I mean, we're obviously big fans of having a crisis communications plan. And these are the reasons, when you're planning in advance, you really have the luxury of thinking things through. You're thinking through what are the different types of scenarios that can occur, what type of fallout could we expect, how will we handle this type of fallout? And this helps minimize exposure and minimize risk at the same time, because you've already covered all the bases and you know how you're going to deploy. When you don't know this and everyone's scrambling is when there are gaps and when you're unprepared really to handle your stakeholders' demands. The other thing about this, specifically with Me Too, is that when there's a Me Too allegation, I've seen a lot with my clients, it begets additional allegations, right? The second somebody puts out there, particularly with educational institutions, but other types as well, somebody alleges something, whether it's on social media, whether it's been reported in traditional media, or whether there's just buzz around the organization, others come forward and come forward and come forward. And if you're not prepared for how you're going to deal with additional waves, you're just thinking about this one thing, then you're really not prepared for what can happen. So what your plan should include, there's a lot to consider. There's a lot of technology. There's apps you can use within your organization that help your crisis team be notified immediately when something's happening, help people come together and share information. But before you even get to sort of the technological application of getting everyone together, you need to know who your team is and what the protocols are. Some of the worst situations I've seen in terms of a crisis blowing up have been when too many people get involved and the organization tries to hear from more and more and more voices, whether it's additional board members, and then tries to decide things by massive committee, and that really bogs down the process. And as I said earlier, speed is very important. So, balancing that, having the right voices versus having, too many voices is really important. If you have in your plan, these are the people that make the decisions and this is how others will be notified, you don't fall into that trap of, well, maybe Gregg should be on the call too, because he might have something to say if Gregg's not actually thoughtfully a part of that process. Who are going to be the spokespersons for different types of issues. Sometimes you want the C-level person, but sometimes you don't. And making that decision sends a message about the severity of the institution, also how seriously you take it. And then the different types of scenarios. So Me Too, we're using as an umbrella, but there are there's tons of gray areas. You talked about somebody being called hun, which could be very offensive. And also, I would say to that point, the other people who heard that person calling other people hun should have told that person to stop doing it. And not just the person who's being called hun. But that's one end of the spectrum. And then the other end of the spectrum are really egregious things. So having in your communications plan the degrees to which you handle certain things based on the potential severity, and not just looking at this as one umbrella issue that you're going to handle in one blanket way.
So just let's touch on the crisis response team. Gregg, within Beacon and in other situations that you've had, who's on the crisis response team? Are you having in-house counsel, external counsel? Is there a public relations component to it? How do you go about setting up your crisis management team?
So the answer is, as always, it depends. I don't want to disagree with Sandy much, but I should always be on the team. Your lawyer should always be on the team.
I was just using you as an example. Yes,
course.
legal always has to be.
And legal doesn't, and I say this quite seriously, legal has a particular perspective on things. It's not the only perspective, but I like to think it's one that ought to be considered in figuring out where you end up. So the answer, Gareth, is there's generally a legal perspective that's included on the team. We are fortunate enough at Beacon that we have public relations folks. We have full-time employees that deal with public relations. One of them is generally going to be on the team. Try to include someone from like an operations / management person who's going to have some firsthand knowledge or can get firsthand knowledge about what actually happened. So that's obviously going to change depending upon where the crisis arises from. It's more of a type of position than a person in particular. And then we're going to draw on what the specific allegations are and who that is. We're going to make a decision probably pretty quickly as to whether or not we think we can handle it internally or we think we need external help. So that's almost, I'd say that's probably one of the first two decisions that we're gonna make. One is, who do we need that we can literally call on an internal line to go get into a room? And then we're gonna figure out, do we think we can handle this, or do we think we need outside counsel, and do we think we need outside PR counsel?
And one thing I would like to say about the relationship between legal and PR, I think a long time ago, it used to be sort of this idea that like legal never wants you to say anything and PR wants you to say everything. And I don't think that's really true anymore. I think that people on both sides that know what they're doing are at the end of the day trying to mitigate risk. And that's it. It's not about, creating the best, most flowery language. It's not about pride of authorship of I wrote this or you wrote this. Our best situations when we're helping a client is when legal and PR are working together. And in fact, when we get a call from a client to help with a crisis, the first question we ask is, who's your counsel? We don't want to even talk really or hear what the situation is. This is because of privilege too. But we don't want to get deep into this situation with them. And we're working with a client right now that sort of has no counsel. And they keep asking us questions that bleed into legal territory, and we sort of know the right thing, but they need to have a lawyer. Maybe they should talk to you.
And looking down the line, all those communications are going to be discoverable in the litigation. So all of the emails going back and forth, all of the memos, the communications with the public relations, they're all discoverable. And so that's why in those initial stages, I think it's very important to have either in-house or external counsel involved. How do you go about selecting a spokesperson, Sandy? Does that vary from situation to situation, or do you recommend in your response plan that you have a consistent spokesperson?
So one thing that we believe at the Castle Group is that the third-party PR firm should not be the spokesperson. It's not what all firms believe, it's what we believe, because it's like, there's your hired gun speaking on your behalf, and that doesn't speak to these things, right? Transparency, authenticity, et cetera. People want to hear from the institution itself. Who it is within the organization varies. You know, if it's, and I'm thinking, we work a lot with schools, so sometimes if it has to do with an athletic department, it should be the highest ranked person over athletics, if that's where the thing is happening. Sometimes it should be the president of the organization. Sometimes it should be someone, you know, a little bit farther down. It could be security, depending upon what it is. That's why going back to that planning is so important, because if you're isolating, these are the potential things that could happen, and you're building kind of a response scenario to each one of those things, you've already identified, well, you know, if it's this really bad thing, that has to be the CEO. If it's, you know, questionable thing, before the investigation has happened and we're really not sure and we actually think it might not turn into a really bad thing, maybe that's not the CEO. But it also depends on the organization's culture. It also depends on how that organization communicates with its stakeholders in a regular way. So if it's somebody that's like never heard from and then they're the one issuing the statement, that sends a signal. If it's someone that, you know, if it's a CEO who's really hands-on, that communicates a lot, that's, you know, either by video or, you know, electronically or in person, town hall meetings, then you would expect to hear from that person, and then not hearing from that person sends a message. So there is no one size fits all, and that is, going back to the plan, why it's so important to plan for each case.
Yeah, I mean, the other thing I would add to that is you can't be wed to, the plans are all good, but the best plans are fundamentally outlines that you then got to figure out exactly. And the right person, because of position, might be the wrong person because they are incredibly uncomfortable if they have to actually say something publicly. And even though they might have the right words, if they come out as insincere because they're sweating profusely and they just are so nervous about saying anything, that's not really the right person. And so you just got to make sure that you've got the right individual that can actually communicate the message that you've agreed upon to get out to.
One thing I would say about the Me Too thing to think about with regard to spokesperson is if it's an organization that's heavily male, and like, don't decide that your spokesperson should be some woman way far down the food chain just because it's a woman, because that sends the wrong message. I mean, it's so obvious and overt if you do that. And, you know, I would say to get ahead of that, make sure you have more gender balance in your organization. But, you know, don't sort of like pick a token person as a token person. It really does not send a good message.
Agreed.
So these are some of the things, if you do have a plan, to your point, Gregg, that you can have the best plan. It can be so airtight, you can think you have everything covered, but all these things can happen. Something can happen, like in your organization, a time difference can create, you know, somebody's already home when the thing is blowing up in another place, or particularly with an international organization. Cultural considerations and language barriers. You know, if you are working in an international organization or you have a large international contingent here, that may perceive things differently. There's so many nuances that can affect your plan, and sometimes it can be really something stupid like technology not working that you're relying on to help you through the situation, or you know, or weather delay. So you can mitigate as best you can for many things, but something I think will always happen that you couldn't plan for, which is why having, you know, that tight team that you know you can trust and rely on, whether it's internal or external, who have already been identified, can help you decide how to fix these things very quickly.
You know, the key concept that I tell my clients time and time again is our job is to mitigate and understand risk, not eliminate it. No such thing as eliminating risk.
So I think we're going to skip this because we've talked a lot about a lot of these things and we're short on time, but I'm happy to share this with anybody later. This is what I was referring to earlier. So you can read it. It is funny, but it's really not, because this is actually what happens sometimes when you're working on creating a statement. You probably deal with this all the time too. you're working to create a statement and people are picking over one word, and also, the clock is ticking, the people are outside, with their torches, and you're fighting over word, and also, that's just such a passive-aggressive statement. That's the funny, not funny part, too.
We already talked about the Andy Rubens situation. In the interest of time, I think we'll skip over this. And go ahead to Lauer, because I think there are some concrete examples to learn from his situation. So I think we're all familiar with what happened. It was shocking allegations about lewd remarks he'd made, giving sex toys, quizzing female producers about their sex lives, just generally wholly inappropriate conduct over a number of years. Andy Lack was the president of NBC News, and I think this goes to the lack of preparation for the situation that NBC News must have had. They fired him on the 28th, and the next morning he comes out and announces that this is the first time that they've received any complaints about it. And I think that he probably believed that in some sincere way, because he hadn't been at NBC News throughout Lauer's entire tenure. But huge mistake, because it came out later that, of course, there had been a host of remarks and conduct that had happened throughout the years, and there had been complaints. Ann Curry came out later and contradicted what Lack had said. So I think the big takeaway from this is you got to have a united strategy. You can't just have somebody who's the head of the organization, who's throwing his or her weight around, coming out and making statements, in this case internally, that might lead to damage of the brand.
Can I just touch on that? One other thing about that is not speaking in absolutes if you really don't know that that absolute is absolute. And that's when we do a lot of work with independent schools and also with faith-based organizations. And, with all the sexual assault allegations and misconduct, schools that came out and said, like, this has never happened here, and then it had. So you don't make a statement that is absolute unless you can say things like, to my knowledge, and we haven't been aware of, but it will turn around and bite you if you can't know the whole history from the beginning of time of everything that's happened in your organization.
So mistake number 2 was Lack came out and he described the events to employees, saying that they occurred at the Sochi Olympics. And this really, the accuser wanted to stay anonymous. This was not somebody who came out and had posted on Twitter or Instagram the allegations. And this enabled people to narrow down who the individual was, and it caused great embarrassment for the accuser and was a stain on the company's reputation. Mistake number 3, in hindsight, they did this investigation internally. Their general counsel conducted the investigation. Without getting into what they ultimately concluded, I think the big takeaway from this was that they had extreme criticism, both from their own workforce, but from exterior, about the neutrality of the investigation. Lastly, several months after the Lauer allegations came out, there were accusations made against Tom Brokaw. And these were many years in the past, obviously. But the big takeaway from this was that a number of female employees came out and signed a letter in support of Brokaw. And a lot of female employees who were sort of being coerced to sign this letter and support Brokaw felt coerced. They felt harassed in and of themselves for wanting to sign this letter. And so trying to circle the wagons in sort of an ad hoc way from the seat of their pants really backfired on the company, and again was a stain that just kept lingering. This was a crisis that should have been put to bed swiftly and quickly back in the fall of 2017, but really continued to linger into the summer of 2018. So I think we're at the conclusion. Any questions, comments, anecdotes that the audience wanted to present?
I have a question. Regarding
Do you mean legally, or do you mean from?
Non-legal first?
Sure. Well, non-legally, we have worked with individuals who have been accused. It's really hard. It depends on the institution. And I referenced earlier, we work with the school. People sort of know who the person is before anything happens in some instances. And so, that's another instance where we don't want to be out in front being that person's spokesperson, because then it makes them look immediately guilty. It depends if they're still in the organization, if they're on leave, if they're not on leave, that sends a message. But I think, helping them with their reputation, you can't rush to judgment either way at the beginning when an allegation is made. So what happens a lot of times is that once the allegation is out there, and if people tend to know who the person is, there are people that support that person, and there are people that don't. And it becomes like a social media fight, and sometimes there's campaigns about, bring so-and-so back, and people that didn't experience the thing that is being alleged are very upset. That's why the investigation, and I think the transparency of this is what the process will be, is so important. Because if people don't know what to expect and don't feel that it's fair and that there is a process, either side can really aggravate the situation. But I think legally, it's really important, because that's where there's risk as well.
Yeah, and I think this goes to the speed of the investigation. I've seen it so many times where the investigation lingers on far too long and it alienates people. I think that setting clear expectations for the accused is also important. They have to understand, and if they're a sophisticated employee, they likely do understand that this is going to be a long process. And the allegations should be explained to them. They have a right to know what the allegations are. They should have the right to present their side of the story, witnesses and evidence that they have. And I think, Gregg mentioned an anecdote earlier about when the accused really felt some embarrassment about a situation, didn't divulge information that was exculpatory until well after the investigation, really put both employees in peril. So being forthright about what the allegations are, when appropriate, divulging the evidence is important for the accused.
Yeah. I think it is very difficult to manage. I think the other thing that complicates the discussion around this is we use the term confidential a little bit loosely. And it actually has, I think it's important to try to give it a little bit more precise meaning in the context of these situations. So, so much of it, I believe, is setting expectations. I think that's just another way of saying transparency. That's, to me, they're synonymous, at least here. And when an accused wants to make an allegation, a report of some alleged wrongdoing, you can certainly say to that person, look, we're going to keep this generally confidential. We're not going to post it on the company's intraweb that you've now made this allegation. But we'll go so far as to say that for the most part, it can't be completely confidential. And you shouldn't tell the person alleging that it can't be. Because, unless it is a claim that can be wholly substantiated or refuted by sort of tens of thousands of people who don't have anything to do with it. If somebody says, hey, look, they were on film and they saw me doing this, and you don't have to talk to anybody, and we can go look to the videotape and yes or no, that's pretty rare, right? So if you, and this, in my mind, is at the heart of the legitimacy of the investigation. If you're going to conduct an investigation and not tell the accused what are the allegations and where they're coming from, well, then they can't really defend themselves, or it's awfully hard to. And you tell the accused, look, we're telling you that you need to keep this confidential to yourself. I mean, you want to go get counsel, so be it. Can't stop you from doing that. But you can absolutely say to that person, if you start talking about this with other people, we will consider that in violation of our policy, and your decision to share that information can result in discipline up to and including discharge. So don't talk to anybody, but here are the allegations, here's where they come from, here's what you allegedly did. What do you say? I think you have to do that. Because if you don't, my job is to protect my client, which has always been the employer, except for a few pro bono cases. And the way that I can best protect my client is to actually be able to say, truthfully, we conducted what we think is the most reasonable investigation under the circumstances. That investigation resulted in the following facts, and therefore, from those facts, we made the following decision, and we think those facts support that decision. If I can't get the right facts, I can't make the right decision as a general matter. And I mean, I'm probably incredibly naive to say this, but I think that's what most people want. That's what they're looking for. You don't have to you should try to get the right answer, but there isn't always a right answer. The right answer is one that is reasonable based upon an investigation that should uncover those facts that are most material. That's the right answer. And if you do that, you'll probably escape problems 9 times out of 10. There's always that one time where despite doing everything right, you still lose, right? That's why we have court.
So I want to again thank all of our presenters today. Again, thank our sponsors, Coveris, Morrison, Mahoney, Reputation 911, and Raskin Partners. Thank all of you for coming. Copies of the materials will be emailed to all of you. I hope you enjoyed your day, and